All right, let's come back to order. All right.
Your Honor, before the jury returns, Your Honor, the next witness that we intend to call is Luis Santiago, father of baby Antonio. Your Honor, we had a motions hearing yesterday regarding witnesses Sandra Holboy and Angela Carter in connection with a motion to dismiss for outrageous misconduct. That motion was denied. The court did hear evidence at that time in the form both of a proffer by way of the contents of the motion itself and actual testimony from both of the witnesses describing some but not all information that the defense believes is relevant to the case at hand. Your Honor generally referred us to the rulings of the morning with respect to the admissibility of certain conduct and statements of Sherry West, Your Honor, specifically prior incidents of child abuse and drug use. Your Honor, those rulings are similar in some ways to the issues before you now, but in other ways very different. The same authorities cited by the court, Scott v. State and Dodd v. State, would be the starting point for the analysis, but we believe the actual analysis itself is quite different. Of course, Mr. Santiago has gunshot residue on his hands. That's already been put into evidence. I don't see how anything relating to his possible role in this crime can be considered collateral, and certainly the fact that he had threatened to kill children on 2 other occasions and further taunted the people he was in relationships with statements like, "I'll have an alibi and they'll never know it was me and they'll never find the evidence," and that's a gross summary of what the court heard in specificity by motion and in the way of the testimony. There's no question that those statements are admissible under the authorities previously cited. Now, some of the other...
Which statements now? I mean, the statements that he, I mean, anything that happened while he was at the hospital, is that what you're saying? I mean, other than the...
Certainly anything he said at the hospital.
Other than the privilege.
Certainly anything he said at the hospital we can go into.
Certainly.
Even with respect to privilege matters, if he said them in the presence of other people, then they wouldn't be privileged.
Well, I think we established yesterday there was only one statement that's privileged, and that's going to be the one that was just with him and the pastor alone. All the rest were inside the...
No, sir. I'm sorry. I didn't mean any disrespect. I wasn't trying to cut Your Honor off. All we heard from yesterday was Reverend Culpepper and what he heard.
Right.
But if Santiago said other things before or after Reverend Culpepper was present and alone with him, I mean, I think that is affirmatively what the state intends to put up in their rebuttal. Those statements would not be governed by the court's ruling yesterday. Moreover, any
I ruled that way yesterday.
Yes, Your Honor. Now, with respect to Ms. Holboy and Ms. Carter, as you recall from the testimony yesterday, during a domestic dispute, Mr. Santiago threatened Sandra Holboy, specifically threatening to hire a quote-unquote crackhead from quote-unquote the city, a city subsequently identified as Minneapolis, to kill her and her children, and that he would have an alibi and that nobody would ever know that he was responsible. Ms. Carter, also Ms. Holboy reports that Mr. Santiago lied during his testimony at the motions hearing when he suggested that he was not familiar with gunshot wounds, when in fact his sister was shot to death in New York and he was present for the open casket funeral. And her testimony was specifically, he knows what a gunshot wound looks like. Your Honor, now there are some other statements that are less direct. More to the point, Ms. Holboy stated that she called the local police department when she learned of the death of Antonio Santiago, and because she suspected that the father, Luis Santiago, may have had a role in the death of baby Antonio. And she described yesterday in great detail very specific information she provided the police, information which the state has never turned over to the defense in this case. And again, yesterday the issue was whether asserted necessarily, but relevant to establish the theory of the defense is with respect to the blinders or tunnel vision with which the police investigated this case. Likewise, Ashley Glassey has already provided a similar testimony, and Angela Carter, Your Honor, also indicated that while she was in a relationship with Mr. Santiago, that he attempted to kill her while she was pregnant. I believe she indicated he attempted to run over her with a truck, and that during, I believe it was that same dispute, Mr. Santiago threatened to kill Ms. Carter and her family. He boasted, "By the time they find your body, they won't be able to identify you," adding, "Your family will never see your daughter again," Your Honor. Now she also goes into a number of other incidents that I won't review. They're in the written motion that we filed, and we would ask the court to include that as well as the testimony yesterday, the live testimony, in support of the proffer. But again, she also testified in great detail yesterday at the hearing that she contacted the police department here, locally in Brunswick, and gave them identifying information, very specific information, to alert them to the importance of the information she had. And again, the police department did nothing to follow it up and did not disclose it, Your Honor. Similarly, Holboy testified specifically that Mr. Santiago blamed her for the death of their son, just like he did to Miss West in the emergency room, and subsequently in the one or more of the domestic disputes as to which the court has already heard proffers and testimony, Your Honor. For all those reasons, first, constitutionally, as far as our right to confront witnesses, we're entitled to go into that information with Mr. Santiago. There can't possibly be any question here, and I'm referring to the language in Dodd, as to whether the proffered evidence raises a reasonable inference of the defendant's innocence, Your Honor. The Georgia Supreme Court has ruled that a reasonable inference of the defendant's innocence was raised by evidence that rendered the desired inference more probable than the inference would be without the evidence. And there can be no doubt that the suggestion that he's innocent and that someone else did it, in this instance, Mr. Santiago, there can be no question that testimony makes that defense more likely true, Your Honor. These statements are admissible as substantive evidence as to the truth of the matter asserted. They're also admitted for the limited purpose of establishing the shoddy tunnel vision with which this case was investigated by the police departments. And for both those purposes, the testimony in question is admissible.
Anything further?
Your Honor, we're asking the court to rule on that, and in the event that we have an unfavorable ruling, we would nevertheless, although we do not believe any of this.
You're asking the court, one, of course, to rule on the admissibility of the testimony of basically what you can ask Santiago, and then of Holbrook and Ms. Carter, correct? And then,
yes, I think you covered.
Okay. And are you still needing a ruling as to Pastor Wright? I think Pastor Wright Culpepper.
I believe Pastor Culpepper. I believe the court's already covered. But we do need a ruling with respect to the admissibility of Ms. Holboy, Ms. Carter, with respect to whether, if the court's going to impose any limitations or allow it only for a limited purpose. Before we examine them and examine Mr. Santiago, we would certainly like to know that. If the court is inclined, and however wrong we think it is, to rule that some of this is collateral for some reason, we would want to verify that we will nevertheless be allowed to ask Mr. Santiago about the same information, whether or not the court, pursuant to the court's interpretation of the 600 rules, whether we're going to be allowed to go beyond the answer provided by Mr. Santiago with Ms. Holboy and Ms. Carter. So there's a potpourri of rulings required and clarifications required from the court. We weren't required under the rules to bring this to the court's attention before we entered into the examination of Mr. Santiago. But given the importance of all this evidence and the potential impact on the case, we did think it was appropriate to ask the court to address it in specificity before we went into this next round of witnesses.
Anything from the state?
No, Your Honor. Everything that the state said yesterday we incorporate in response to that.
The law is quite clear that for a defendant to introduce evidence implicating Santiago in the commission of a shooting death of his son, that proffered evidence must have a reasonable inference of the defendant's innocence. It must directly connect Santiago with the corpus delicti, or show that Santiago has recently committed a crime of same or similar nature. That burden is on you, Mr. Goff, and the court finds that you have not met that burden. Evidence that merely casts a bare suspicion or another raises a conjectural inference as to the commission of the crime by him is not admissible. The court finds that after hearing Sandra Holboy's testimony yesterday, she was married to Santiago for 12 years, during which time, according to her testimony, Santiago was abusive, both mentally and physically. He was addicted to drugs, that he made horrible threats to her life and their children's life. She admits, however, that she hasn't seen or been in his presence, I believe is what she said, for over 15 years. She hadn't spoken to him in the last 6 years, said that she called law enforcement to tell them of her experience with Santiago because she suspected that he was involved. The next witness, Angela Carter, another ex-wife, but she was engaged, and they had children together. In her testimony, as I have it noted, she recanted similar instances of abuse and addiction again, though she admits that her relationship with Santiago ended over 10 years ago, and that she reached out to law enforcement because she too suspected Santiago could have had something. Their speculations based upon their relationship with him 15 years ago, 10 years ago, is nothing more than just speculation. Neither of them place him at the corpus delicti of the crime, nor do either one of them show that he recently committed a crime of the same or similar nature. Therefore, any questions, unless they have some admissible relevant testimony as to the crime that we're on trial on, your permission to question those is denied.
Your Honor.
You want to take exception? Go ahead.
Well, we can take exception under the constitutional confrontation issue and due process arguments previously raised, Your Honor, under both the federal and the state constitutions. Beyond that, we need further clarification from the court.
Okay.
Your Honor.
As to Santiago himself?
As to Santiago, will we be able to be allowed even to inquire, knowing that we cannot follow up with the actual testimony of the witnesses? Mr. Santiago doesn't know that, presumably, and therefore we would at least like to be able to.
You can ask him relevant questions on direct examination of where he was in the time frame of this shooting. I'm not going to allow you to go into his marriage of when he was married 23 years ago and domestic problems that he had and his version of what we heard last night. I'm not going to let you ask about the engagement unless you can. The court has found that they have no connection. That these ladies, these ex-wife and ex-lover, that their troubled relationship with him, and that their speculation that he had something to do with it is merely just that. And so we're not going to proceed with that here in the trial.
I understand the court's ruling on that.
Okay.
And further, is the court going to allow us to present the testimony of Sandra Holboy and Angela Carter for the limited purpose of supporting the defense theory that the prosecution and the state in this case investigated this case with blinders and failed to follow up on obvious leads?
No.
Well, I'm glad I asked the question. Your Honor, with those rulings by the court will give us 5 minutes. We've got some witnesses to release, and our next witness will be Mr. Santiago. But we also take exception to the court's rulings with regard to that.
I understand.
And also,
be noted.
I want to put it on the record. I don't think it's going to change the court's ruling. We also contend that the testimony of Sandra Holboy and Angela Carter raises a reasonable inference that the killing in this case was a drug-related act rather than the product of a random robbery. And you, Your Honor, will also direct your attention specifically to the testimony provided from both witnesses that Mr. Santiago, Luis Santiago, had a bad crack habit during the time of both of those relationships, and that he in fact stole the wallet of Angela Carter, acknowledging that he owed money to a drug dealer and that he needed to pay off the drug dealer so that they would not hurt him. We contend that that raises a reasonable inference as to whether the same conduct and motives are at play in the death of baby Antonio.
It'll be so noted for the record, Mr. Goff.
Thank you, Your Honor. If we could have 5 minutes.
Okay.
We just shortened the day a good bit, Judge. 5 minutes isn't too much.
Judge, talk to the juror. She has paid for it. She's worried about her mail.
Counsel, where is it? Don't approach, please.
You need this on the record, Judge?
I do.
Well, he was funny, the constant get it, and so my son goes, you might not want to talk to her, tell me about the phone and I'll work with it. So literally when I was telling my 10-year-old, she was like, it's a Samsung Galaxy. S3. Is it a 3 or 4? I think it's a 4. He's, okay.
Your Honor, our next witness is Louis Santiago.
Bring him out. Go ahead and get him out.
Before we do that,
Not break for the day, I'm talking about just break after this. After Derek and all crawl. It's not 3 hours or something.
Only 3?
See, please, sir, we're going to be at ease just a minute. You need some water right there.
Yeah, I sure do.
Mr. Miller, you can stay right there, or you can sit over here in the corner after right where the deputies, it's up to you. You want to sit up against the wall? Okay. Give me a thumbs up when they're ready to go. Do we have Miss Copeland's cell phone number so we can reach her?
I don't have Ms. Copeland's cell phone number.
Okay, let's all rise.
It's all right for the jury.
Bring them in. witness.
Your Honor, the defense calls Luis Santiago.
I want you to stand up again and face the clerk here. Raise your right hand, please, sir.
You do solemnly swear or affirm the evidence you shall give the court and the jury on the issue at hand shall be the truth, the whole truth, and nothing but the truth, so help you God?
Step close, please, sir.
May I proceed?
You may.
Santiago, would you please provide your full name for the record?
Luis Angel Santiago.
Mr. Santiago, how long have you known Wilfredo Calix Flores, also known as Pastor Freddie?
We met 3 years ago.
Do you recall whether you ever lived at a boarding house next to Pastor Freddie's church?
I did.
We say close to. That would be the residence immediately adjacent to the church?
Yes.
And when I say immediately adjacent, within several inches of the church?
Yes.
And the residence in which you lived, did it not have a porch?
Yes.
And during the last 3 years, were you smoking or a smoker? Or during that 3-year period, were you a smoker?
No.
No. Were you in the habit of sitting outside on the porch?
Occasionally.
Sir, do you remember testifying previously in this case?
Yes.
Several weeks ago?
Yes.
Do you remember my asking you the question, did you spend a lot of time out there just observing people go by?
Occasionally.
Do you remember the question?
You asked me if I go out there constantly.
So you did go out there constantly?
No, sir.
Your Honor, may I approach the witness?
Thank you.
Sir, I'm showing you page 166, a transcript from a previous hearing. Directing your attention to line 3. You read about 6 lines of that. Review that for me. Don't read it out loud.
Starting from 3.
Starting from 3.
Did you spend a lot of time out there just observing people go by? No. It's briefly. I used to sit outside when I used to smoke at the time.
Thank you. So when you testified a moment ago that you didn't sit out there smoking, that was a lie.
I said occasionally.
When you said you didn't sit out there smoking earlier, that was a lie, wasn't it?
No, sir.
Well, can you explain why you were able to remember that you would sit out there smoking 3 weeks ago, but you could not recall that this morning?
I didn't say I was smoking at the time.
Sir, your previous testimony was, I used to sit outside when I used to smoke at the time. Yes?
I used to.
And you would go out there and smoke a cigarette. Yes?
Occasionally, yes. Not all the time.
And you were out there when the pastor or his church acquired the building next door to your residence.
Not all the time, though.
So you did observe the construction going on at the church next door?
Your Honor, I object.
Yes,
This
one time.
witness, just a moment. This witness is on direct examination, and almost from the beginning, Mr. Goff has been asking leading questions suggestive of the answer. And I object to leading the witness. Let him ask, what if any? What if any? How far? Let him ask the proper questions on direct examination and not leading. I object, Your Honor.
Your Honor, when we get to the point of impeachment, when we're going over prior inconsistent statements, we are allowed to lead to the point of pointing out the prior inconsistent statement.
That's where you say you are now, Mr. Goff?
That's where we were on the last question and
All right,
two
well,
before
from
that.
here on out, I mean, unless you're at an inconsistent statement, don't lead the witness, please.
You did see the construction going on at the church, did you
Objection,
not?
Your Honor, leading.
I'll rephrase. Did you or did you not see the construction underway at the church next door?
Yes.
Did you or did you not see that construction through a big window on the church?
Yes.
Were you or were you not already very familiar with the building in which Pastor Freddie was making his repairs?
Yes.
And that's because you used to work, I'm sorry, did you or did you not previously work in that same building?
Yes.
Did you or did you not previously do temporary work for a temporary services company in that building?
Yes.
Did or did not the church next door to you reach out to you as part of their ministry?
No.
Do you recall whether Pastor Freddie Wilfredo Calix Flores reached out to you as part of his ministry?
No.
Do you know Pastor Angie Rivera?
Met her one time.
Did or did not Pastor Angie Rivera reach out to you as part of her church's ministry?
No.
Did you or did you not develop a relationship with Wilfredo Calix Flores?
No.
Did you or did you not develop a relationship with Angie Rivera?
No.
When was the first time that you spoke? No, hold on. Let me back up. When was the first time you had contact with anyone from that church?
About 3 months ago.
Your testimony today is that you first initiated contact with someone in that church 3 months ago?
I made a phone call.
Well, we'll get to the phone call. But you had contact with people in that church prior to that phone call. did you
Objection,
not?
Your Honor,
Sir.
leading.
Sustained.
Did you or did you not have contact?
Goff, the standard for leading is whether or not to suggest an answer. Asking did or did not before putting a topic. Ask general questions, who, what, where, and when. Do not suggest answers.
When did you first meet Wilfredo Calix Flores?
2010.
3 years ago.
3 years ago.
So when you said a moment ago that your first contact with him was 3 months ago, that was incorrect.
No.
Now, you had further contact with Wilfredo Calix Flores approximately 3 months ago? Yes or no?
No.
I'll rephrase. Do you recall whether you had any contact with Wilfredo Calix Flores 3 months ago?
No,
You don't recall, or you did not?
I did not.
Do you recall whether you had any contact with the senior pastor, Angie Rivera?
Yes,
When was that contact?
3 months ago.
Was that the first contact you ever had with her?
That would be my second contact with her. The first time I met her, 3 years ago, and the phone call when I was calling her to let her know I was the baby's father.
Very good. So, do you recall whether you had any other contact over the last 3 years with the people in the church right next door to your residence?
No,
Why did you contact Pastor Angie Rivera after the shooting of Antonio Santiago?
I was letting her know that I was her, the baby's father that got killed, and I wanted her to pray, the church to pray for me and the mother.
Had the church ever prayed for you or the mother or the child ever before?
No,
Had you ever expressed any interest in their ministry ever before?
no,
But your testimony today is that after having had absolutely no contact with anyone in that church for the 3-year period you lived next door, after your baby died, you reached out to them for help. That's your testimony?
I just wanted to call.
I'm sorry?
I called to get prayer.
You called to get prayer. Was there any other reason why you called besides to get prayer?
Yes, I was asking for the pastor.
Well, we know you were asking for the pastor, but why were you asking for the pastor?
That the gentleman that shot him was the one that shot my son.
You called Angie Rivera trying to reach Pastor Freddie because you wanted to talk to him about this case involving the death of your son.
But I never did.
That's right. Your testimony is that you never got through. And that you and
Right.
Pastor, you never actually talked to anyone in the church about it.
Right.
Well, I thought a moment ago you said you were reaching out to them for prayers. Was that a lie?
No,
Well, did you decide you didn't need prayers? That baby Antonio didn't need prayers after you didn't get a call back?
Antonio didn't need any prayer. He was dead already.
How many other churches in the community did you reach out to for prayers after your child was killed?
The prayer was for us. Quite a few churches.
So you were just randomly calling this church among many others?
Yes.
But you've already said you did want to talk specifically with Pastor Freddie about this case. Did you not?
No, it wasn't about the case. I just wanted to talk to him.
Do you remember being asked previously what the purpose of the call was?
No.
Would it refresh your memory to review that part of your previous testimony?
You can?
Yeah, approach your honor.
Okay. Mr. Santiago, the procedure is these will hand it to you. You can read it silently to yourself, and then if it refreshes your recollection, then you can testify for your recollection, not from what you read, okay? So it's only if it refreshes your recollection. But read it silently to yourself.
Take a moment, if you will, and read page 164 to yourself. review your previous testimony?
Yeah.
Again, I ask you, what was the purpose of the call?
I was going to tell him that the same gentleman that shot him shot my son.
Were you there? Were you there when baby Antonio was shot?
No.
Sir, you previously testified, I was making sure he reported the incident when he got robbed that same day. That was your testimony then, wasn't it?
Rephrase that again?
You previously testified that the purpose of the call was to make sure that Wilfredo Calix Flores reported that he had been robbed.
No, sir.
Well, you'd agree it would make no sense to ask him to report a robbery that had already been reported.
Argumentative, Your Honor, objection.
I'll rephrase. What purpose would be served by asking the pastor to report a crime of which you were already aware and which the police were already investigating?
Exactly. I wasn't going to talk to him about the case. All I mentioned was the gentleman that shot my son shot him. And if you know, that was my baby that got killed. And that was it.
Sir, do you recall being asked the question, did you want to assist him? Is that what the purpose of the call was? You thought somehow you could be helpful to him in identifying Mr. Elkins, and your answer, no, there was no assistance. I was going to ask him why he didn't come up, why he didn't, I was making sure he reported the incident when he got robbed. You don't recall saying that under oath?
This already had happened already. He was all over the newspaper, the young man.
Because that wasn't the reason for your call, was it?
No, I wasn't going to talk to him about no case.
You called, did you or did you not call Wilfredo Calix Flores for the purpose of making sure that he identified Marky Elkins?
No, sir. No, sir.
Let the record reflect that showing would have been marked for identification purposes as defendants exhibits 54 and 55 to this date. May I approach the witness?
You may.
Mr. Santiago, I showed you what marked for identification purposes. Defendants exhibits 54 and 55. If you could review those for me. Directing your attention back to Defendant's Exhibit 54, a document purporting to be a criminal conviction for the offense of aggravated stalking in the Superior Court of McIntosh County. Are you or are you not the same Louis Santiago that was found guilty of that offense?
Yes.
Your Honor, at this time we would tender Defendant's Exhibit 54.
Any objection? Admitted without objection.
Directing your attention to Defendant's Exhibit 55, are you or are you not the same Louis Santiago convicted of the offense of deposit account fraud in the Magistrate Court of Camden County, Georgia?
Repeat the question.
Yeah, I don't recall.
Are you or are you not the same Louis Santiago convicted of the criminal offense of deposit account fraud in the Magistrate Court of Camden County, Georgia?
Yes.
Your Honor, at this time we would tender into evidence Defendant's Exhibit 55.
Admitted without objection.
Do you recall, sir, going to the hospital on the morning of March 21st, 2013, that hospital being the Brunswick campus of the Southeast Georgia Regional Medical System, or Regional Health System?
Yes.
Do you recall how you got there?
Car.
Okay. Whose car?
My neighbor's car.
Right. When you got to the hospital, did you encounter Sherry West?
Yes.
Did you or did you not say to Sherry West, why didn't you give them what they wanted?
Objection, Your Honor. That is a leading question. Ask the witness what, if anything, he said to Sherry West. I don't know how many times this court has to instruct this lawyer to ask a question that is not leading on direct examination. He doesn't have him on cross. I will, but he doesn't.
Y'all, objection sustained. Ask who, what, where, when, why. Don't
I'll rephrase, Your Honor.
suggest an answer.
What, if anything, did you say to Sherry West when you met up with her at the hospital?
She was crying, and I grabbed her.
My question, sir, was what did you say to her?
Where's the baby?
What else did you say to her?
That's it.
Did you ever ask Miss West why she didn't give them what they wanted?
No.
That never happened.
No.
Have you ever told Miss West that she was responsible for the death of your son?
Your Honor, again.
No.
What, if anything, did he ever say to her about responsibility for the death of the son? That's the way you ask a question on direct examination.
I'm sorry, was that an objection, or is this like some kind of teaching?
Hold on. Gentlemen, one at a time.
You know, I mean, I've objected. Your Honor has sustained his objections. I object on the basis that it's leading. I mean, by this time, he ought to know what the court has ruled repeatedly on this. Your Honor, please, make him ask direct questions, Your Honor, please.
Your Honor.
Direct examination.
This time I'm going to ask for permission to examine the witness as a hostile witness. The presence of his attorney, Jonathan Miller, in the courtroom during these proceedings certainly is evident that the relationship between the defense and Mr. Santiago is a hostile one.
Your Honor, object to that. What hostility has this witness shown to Mr. Goff? If there's been any hostility, it's been on my part because he won't ask questions correctly. This witness hasn't shown that he's been hostile. He's answered every question apparently truthfully, honestly, to the best of his ability. I haven't seen him hostile, and I object to that, Your Honor, and ask that he not be declared hostile.
Your Honor, in what world is lying to a lawyer under
Hold on,
oath
hold on.
not a hostile act?
Motion for hostility is denied. Mr. Goff, once again, let's ask basic questions. Who, what, when, where, why, what did he do, what did he do next? What did he say, if anything, without suggesting anything to him?
Do you recall whether you were rude to Miss West at the hospital?
No.
Do you recall whether you were cold to Miss West at the hospital?
No.
Do you recall whether you were affectionate to Miss West at the hospital?
Yes, I was affectionate to her.
At all times?
Yes, that whole entire time. I even spent the night with her.
Sir, when you left the hospital, how did you leave?
The two investigating detectives escorted her and me to her house.
When you say escorted, were you walking to your house or driving to your house?
They drove us to Sherry West's house, and Sherry West asked in front of the two detectives if I can stay with her to take care of her wound, walk around the house at the time.
Four of you were in a patrol car?
Yes.
And Detective Garrett, was he one of the detectives that you've referenced?
There was two female, Mrs. Smith and the other young lady, can't recall her name.
Detective Tyndall, perhaps?
I suppose, yes.
Your Honor, I have no further questions for this. Well, I do have one further question for this witness. Mr. Santiago, can you think of any reason why you might want to testify today favorably for the state?
I can call him as a witness, and I don't know whether he wants to, he's testified truthfully. Why would he ask that? What's the relevance of that?
Your Honor, the jury will decide whether he testified truthfully.
Right.
And I'm sure that Mr.
I'm
Economou is
gonna
aware
let
of
him
the
out.
relevance. But we can take it up at sidebar. The last thing I want to do 2 weeks into this case is cause a problem.
Hold on. Cannot.
Say no anymore.
He's-
I'm we'll overrule the objection, let him ask the question. If he can answer, if he has an answer, I don't know if he does or doesn't.
Is there any reason, as you sit here, why you might feel an urge to be helpful to the state in the prosecution of this case?
The state didn't subpoena me, you did.
Thank you, sir, but I'll insist that you answer my question. Is there any reason why you might feel the need to testify favorably towards the state?
Well, they're the prosecutor. They're handling my son's case.
Is there any other reason?
No.
Is there any reason why you might be hoping for leniency from the state through your testimony in this case?
No.
Do you not have a pending criminal charge pending?
Your Honor,
No,
I
sir.
think it's a leading question.
It's over with.
Wait a minute, wait till I
Hold on.
You turn the microphone on.
Again, it's a leading question. Do you not have? That's a leading question. If he's got one, ask it in a proper fashion. What, if any, do you have? What, if any, deal is there? What, if any, agreement? Do I have to teach him how to do a direct examination?
Your Honor, I'm going to move for mistrial. I'm tired of Mr. Economou's commenting and charactering on
The court will make
defense's
the further
presentation.
instructions this time. Mr. Goff, re-ask your question.
What, if any, reason not already testified to do you have to testify favorably for the state?
It's nothing. I'm just here on a subpoena, that's it. I'm not here for any favoritism or anything like this.
Is there not a pending charge pending against you, a criminal charge in Camden County, Georgia?
My charge has been taken care of already. I'm just here for a subpoena. It was violation of probation, and that's it. Once I go back, it's done.
One moment, Your Honor. Sir, were any criminal charges dismissed against you in the last 2 weeks?
No.
Did the state of Georgia, specifically this district attorney, dismiss a charge against you in the last several weeks?
No. Not that I know of. I mean,
Were you not? Was there an incident between you and Miss West after the death of the child?
I stepped on a porch, that's about it. And it was a restraining order.
You were arrested for stepping on that porch, were you not?
Yes.
Because you weren't supposed to be on that porch, correct? Am I correct?
Yes.
So you were charged with a criminal act, were you not?
Yes.
Within the jurisdiction of the district attorney.
I don't know who was it, but I got charged with a charge.
And that charge remains pending today.
No, I got an OR on it, and I did my time on it.
Then why is your lawyer here today?
Your Honor, I object to that. Why is
The
this lawyer
objection.
here? That's not relevant.
Who told you, sir, that you have no pending charges?
I know I don't have any pending charges. I took care of the one in Glenn County and the one in McIntosh.
You say you took care of the one in Glenn County. How did it get
It was an
taken
OR.
care of?
They gave me an OR. I mean,
Oh, okay. So you received, you were released on your own recognizance on a pending case. That's your understanding?
well, if you want to say it's pending, but I'm on probation with that.
You're
So-
on.
Judge, I'm going to object. All of this is, he's
I'm sorry,
asking for,
you have to come right in front of something.
Hold on, let's send the jury out.
It's all right for the jury.
Record reflect, jury has been removed from the courtroom.
Judge, he is asking questions that, number one, I don't think my client is capable of understanding the answer to because he's asking him for legal conclusions. My client was given an OR bond that was opposed by the district attorney's office. However, the magistrate judge saw fit to give him that. There is no deal between us and the district attorney's office. I have never had a discussion with the district attorney's office about any deal on Mr. Santiago's behalf. He remains in jail based on one of those two exhibits, which was a probation revocation from his previous wife that he lived with in McIntosh County, and pending resolution of this case, he will go to McIntosh County, and we will have a hearing to determine whether or not he can be released from that probation revocation. So I have not been privy to the restrictions that were made on Mr. Goff and what testimony he could attempt to get from Mr. Santiago, but I think that any discussions of the case that he is currently on probation with, that he is currently sitting in jail with, would be inappropriate in front of this jury.
Turn your microphone on, or why don't you just come up here to the podium. We'll hear from you, Mr. Goff. Do you have any further questions, Mr. Goff, that you want to?
Yeah, Your Honor, yes.
Okay.
But it'd be helpful to know, Your Honor, we were advised that Mr. Santiago was arrested after the death of baby Antonio in the Brunswick Judicial Circuit, I believe specifically in Camden County. And there was a pending charge against him. Now, if that charge were disposed of, the state has never notified us. The only information the state has provided was that there was a pending charge. Your Honor, the witness cannot, we're entitled to inquire if there's a pending charge. We know there's a pending charge. Now that's been confirmed that it hasn't been dismissed, so we don't have any Brady issues to discuss. But the witness can't simply say up there he doesn't know that he has a pending charge.
You can only say what he knows. I mean, I don't know what he knows or doesn't know. I mean,
Your Honor, he had to be present for the proceedings. An OR bond is not a dismissal.
That's right, it's not.
The fact remains that he has a pending charge.
in his mind, that meant it was taken care of, but I mean,
Well, I guess
whether
we
that's
need to-
correct or incorrect, I mean.
Well, I think he and his attorney need to have a conversation privately before we resume examination of this witness. I mean, it's just inconceivable to me that we would concoct some kind of a situation
Well,
where
you're certainly
defendant-
allowed to ask what pending charges are currently in the district attorney's office. Maybe I can let him have a few minutes with his attorney. We can break, attorney can come right up here and discuss, and talk with him and say, maybe we can get this cleared up so we can move on. I mean,
That sounds like an
they're
excellent
pretty
idea.
simple questions and with some pretty simple answers, and so we could hopefully get through this.
We concur with that, Your Honor.
Okay, let's take 5 minutes, and I'm gonna turn on, can I turn on the white noise up here?
Yes, sir.
So they can have privacy?
Turn the white ones on.
Okay.